All right. Good afternoon, everyone, and thank you all for joining us for today's month of service presentation of evictions and knowing your rights. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and presenting on behalf of our partner with Lone Star Legal Aid. Today we have Mr. Newton Tomeo. Am I pronouncing your last name correctly?
Yes.
Mr. Newton Tomeo, who's going to be providing you all the information today about evictions and tenant rights. Also included in our partnership, we also have Houston Volunteer Lawyers, Texas Legal Services Center, the Harris County Attorney's Office, the Earl Carl Institute, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up a month of service. And a month of service basically is a collaboration of all nine of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, and information to the communities that we all serve relative to community empowerment, asset building, and asset protection. We know that there are a lot of underserved communities that are out there who do not have access to a lot of information, who don't know where to go for available resources, especially those that have financial and legal impacts. So we decided to collaborate several years ago. We used to go out in person into various communities, stay there for an entire month, and then go to a different community with these workshops. But of course, we've had to adjust and adapt to the online platform. But we are slowly still trying to get back out there in the community. So kind of be on the lookout for us to show up in a community near where you are. Um, Today's topic or presentation, again, is going to be about evictions and knowing your rights. This is your opportunity to ask whatever questions that it is that you have in regards to the eviction process, what evictions are, what does it mean, what's the, what are your rights basically in general as a tenant, and where do you go for various resources that are out there that could potentially assist you through this process that you're going through. In addition to that, again, this is your opportunity to ask whatever questions. However, the information that is provided is for educational purposes only. It is not to be considered any legal advice. However, we do encourage you to reach out to our legal service partners if you find yourself in need of any civil legal assistance that you may need. But again, you have the opportunity to ask questions. We do want to try to protect your privacy as best as we possibly can. So do note that we are recording this session and that we are also broadcasting live from our social media platforms and on our YouTube channel. So we want to try to get you to ask your questions or keep them to be as general as you possibly can so that you don't divulge any personal detailed information uh, on this environment. So, we don't want that information kind of getting out there. So don't give us, where you live, name of your landlord, all of that kinds of stuff or what have you. So do keep that in mind as you're asking your questions. Feel free to type your question into the chat. And we'll be addressing all of those questions at the end, or otherwise you can unmute yourself at the end, raise your hand, we'll call on you, however it is that you feel more comfortable with asking your questions. If you are joining us on social media, I am monitoring that as well, so you can feel free to type your question into the comment section, and I'll make sure that your question gets addressed there as well. So without further ado, I want to welcome you all and thank you for joining us for today's presentation. If this is your first time being here, welcome. If you're coming back to support the a month of service and this collaboration, we want to welcome you back and thank you for your continued support. Again, there's a variety of different workshops that we offer throughout the month, but we want to um, ask that at the end of the presentation, there's a link that pops up for you to just kind of give us your input and let us know if there are any resources or workshops or information that you all may need additional information about or would like to hear us give a presentation about, then please let us know so that we can keep that in mind as we are planning our future presentation. So with that being said, we are going to go ahead and get started. I'm going to turn it over to Mr. Newton, and we are have him introduce himself, and we're going to go ahead and get started. So Newton, go ahead and take it
Uh,
away.
Thank you, Miss Murray. My name is Jitin Tamayo, and I'm an attorney at Lone Star Legal Aid. Let's see. I guess sorry, slowly. First, I guess I share my screen.
And also do note that while he's getting that together, that the recording of this presentation, any resources, links, or anything like that that gets referenced, it will be sent to everyone at the after the presentation is over with as well. So don't worry about if you guys come in a little bit late or you may have missed something. You'll be able to go back and watch the recording as well. So go ahead, Newton.
Oh, thank you very much. As I guess mentioned, I'm an attorney at Lone Star Legal Aid. I'm in the Housing and Consumer Unit, and this is a presentation on eviction and knowing your rights and new rights. Um, uh, the- um, I guess since as we'll talk about, since a new law that was enacted recently, SB 38, there's a lot of new tidbits, and even today I'm still learning new pieces of law and how they're being applied in court. Special, I guess, acknowledgement I want to give to my fellow colleague, Kim Ndike. She helped create this presentation. So, I'm with Lone Star Legal Aid. Lone Star Legal Aid is a nonprofit law firm, that serves essentially, I guess, the eastern part of Texas and all the counties. Um, if you, I guess, need help applying, the information is, I mean, you can apply at www.lonestarlegal.org, or you can call, I guess, the number, which I guess it's in also 1-800-733-8394. But I guess this will be, at the end also. Um, the first thing, I guess, this is our agenda. The first things we'll be talking are leases, terminating the leases, notice to vacate, forcible detainer suit, which aka it's that's, I guess, the legal term for evictions. The appeals, I guess what you should look out in public housing or subsidized housing cases. What happens, if there's if your landlord locks you out or shuts down your utilities, and security deposits. So, I guess the first thing to talk about is, that the Texas legislature last year passed SB 38 last session, and it came in effect, essentially, I guess, January 1st. Um, it changes, I guess, like, first of all, it changes, I guess, how the procedures of it, and how, and right at this point, I guess we're sort of learning, I guess, how courts are enacting certain aspects of it. But I mean, if if it's still, so I mean, this, I guess, it still might be subject to change. So, the first thing first, is the lease. Leases control in most disputes. Leases, I mean, change the timelines, of what a code of what the code says, and it can also waive some of your rights. Um, Um, a a lease is, it's essentially just the agreement, that establishes your right to use, the dwelling. It can be either, oral lease, or it can be a written lease. If it's longer than a year, the lease, under the statute of frauds, it has to be in writing. You have a right to your lease, and within 3 days of both parties signing it, they have to give you a copy. And if you don't, I mean, they're required to give you a copy. Um, so, I mean, the first things first is, when there's the dispute is, review what's in your lease. How much is your rent? What's the late piece? How is rent defined? Um, Another thing, I guess, to look is, I mean, what happens after the lease ends? Is there does it have terms, that extend the lease, or into months, which usually happens, or does it automatically close down, and then you'll be subject to other regulations? In certain federally subsidized housings, the that's, I guess, is there an agreement with the housing authority? Um, other, I guess, things is, I mean, well, what is a breach? Some leases have like a higher, more stringent definition of what a lease is, of what a material breach of the lease is. And so, I mean, you'll have to look into that, to see if that's what your lease says. Also, I guess, if you're facing eviction, so most leases, I guess, if while, usually it's like 3 day notice to vacate, it becomes a 24-hour notice to vacate. And important, I guess, what the new law is do you does the lease, I guess, authorize electronic, I guess, communications in the lease, and what's the preferred email to give notice, to the landlord. Um, After, I guess, the initial lease term ends, most parties have a right to terminate to terminate the lease, if it, will continue month to month. And usually you just have to give, one pay period's notice. So, in most cases, it would be, 30 days um, and to let them know, that you're not going to continue the lease. Um, it, your lease contains language regarding the timelines of terminations and when, the notice must be provided to either party. So I mean, look, so just because, I say 30 days, some leases say, you know, that's the usual, standard general rule, but, some leases say if you stay past 60 days, you become a holdover tenant. Except in, I guess, in special circumstances, your landlord, I mean, can't, I guess, force you to, renew a lease, and likewise, terminating the lease, during the initial term is, unless a statute provides it, and we'll talk more about, particular times a statute allows it, to terminate the lease. It, it, I mean, you can be liable for, for the rent, that you would owe, I guess, for the month that you didn't, that you're leaving. You still are liable unless the statute, some statute allows, for, if repair and remedies. But I mean, we'll talk that in more details. If these are some instances, where the statute does, I guess, allow, and you can, I mean, you can leave a lease early if you give notice. Um, yeah, if there's an instance of family violence, you don't want to be, be, I mean, with, a potential, I guess, tenant that might cause you, harm. Um, Certain, stalking or sex offenses also, can't, I mean, and those can be waived, but I mean, if that happens, you have a right to, terminate the lease. If the tenant dies, um, it ends at that point, and they can't go after the state if you get proper notice, and I mean, in certain military service, but I mean, but the landlord, I guess, and tenant can waive that right. But if you go to war, and most times, I mean, the soldiers, they will give them the right to terminate early. There are other instances, I guess, that, if, like after Hurricane Harvey, a landlord could terminate, the apartment complex, if, and end the leases, after Harvey, because I mean, there was an active, storm that caused a totality. It wasn't anyone's fault. And the landlord, had the right to terminate, of the property if it was, completely unusable. I mean, it really depends, I guess, I mean, what your lease says, but I mean, if there's more to it, but yeah, after Harvey, I remember that was a common issue, we saw, um, was, landlords, just, I guess, terminating, I mean, all their tenants, because, I mean, it was flooded, and I mean, and you couldn't really repair at that point. In order to terminate your lease, vacate the premise, review each statute, and I mean, and look at what the statute requires and timelines, every instance, of the statute, I guess, the reference above, tells you when landlord, when you should tell the landlord, and when, and what happens if you don't. So, I mean, this the termination of the lease, due to a breach. This is, I guess, what happens, if you, default on the lease. You, your lease, I guess, if you have a written lease, it'll tell you what a breach is. Some common breaches, by tenants, is failure to pay the rent. Violations of the community policy, unoccupied tenants. Um, criminal activities, or in some instances, if they don't, I guess, allow you, if the lease doesn't renew automatically, if you hold over after the lease. If the breach occurs, a landlord, I guess, has to file an eviction and give you proper notice before filing an eviction, and allow you the time to to contest it, and they'll have to prove it in court. So um I guess the most important thing, I guess, is if you're having trouble, I guess, with repairs, is don't withhold rent. But nothing good ever happens. So in Texas, I guess you have a right you have a right to, I guess, for the landlord to do repairs, if it affects, your health and safety. But after you don't pay, I guess, rent, if you're behind on rent, the landlord at that point is no longer obligated, and if you withhold rent, and even though, I guess, it's allowed in certain circumstances under statute, it's very wrong, and most times, a a I mean, I guess, even, I guess, lawyers, I've seen them advise their clients wrong on this issue, and so, I mean, if you're, I guess, having issues with repairs, and I mean, best thing is, is to apply and get help, because, I mean, um um there's a lot of, I guess, false information online, and whether, with the TikTok and the social medias, that I mean, at times, I guess people can be led astray, and I mean, it's best to, go to someone that practices this type of law. Um, so, the first thing, I guess, before, I guess, filing eviction, a landlord has to give a notice to vacate. So, um, the code, I guess, the general rule, under the code is 3 days, unless your lease says otherwise, which is usually under. But a notice to vacate just says, you have to leave by on this day, and if you don't leave, I guess, by this day, then we're gonna file a lawsuit. Um, um, it's, I guess, the new law, I guess, made it easier, and it can be hand delivered, mailed, certified mailed, just posted inside, or electronically, if if your lease allows electronic notices. If you're, I guess, even if your, I guess, landlord doesn't deliver the notice, but you're still know of the eviction, and go to trial, now, I guess, you're essentially, it, um even if your landlord fails to deliver the notice properly, the landlord can still win this eviction, just as long as, I guess, that there's a notice to vacate out there. Um, so, a good, I guess, aspect of the rules that they enacted, I guess, under SB 38, is that now there's a notice to pay or vacate. So, if a notice to pay or vacate, I guess, is required, is if the eviction is only for non-payment of rent, and if you weren't late the months before the notice is sent, um, the landlord has to give you an option to either pay the amount, which they have to list the full amount, the date it's due by, and and that this and that they'll, I guess, file eviction if not, or for them to vacate. And if they don't, I guess, if they don't send this notice, it's given the option to pay beforehand, and the rule of, if you weren't late the month before, and it's only for non-payment, I guess, the defendant would win in that case. Um, even if the landlord, I guess, it's not required, but they give you the option, I mean, they have to see the option through. Um, and a reason, and this is, I guess, and this rule only applies, I guess, once per lease term. So it every, I guess, you only get, I guess, the option to pay or vacate release well, I guess once per lease term. I guess the first thing, I guess, when knowing, I guess, I mean, to pay a rent or vacate is, I mean, what is rent? I've seen leases, try to include, I guess, other charges as rent, and so I mean, I guess the first starting point is to look at the lease. It shouldn't include utilities or late fees. And if if it, and so I mean, but I mean, I guess the best practice is to pay the full amount that the notice gives you. I mean, because I mean, at that point, you're kind of, it becomes, I guess, I mean, an argument, and so weak argument, and in most courts, I guess, would favor the landlord at that point if if you. But so, um, I mean, there are special cases, actually when I guess it's a non-payment for rent, and and the tenant actually tenders the full amount, and rent is refused. Landlord is not free to refuse properly tendered rent pursuant until to lease agreement or a notice to pay or vacate. I mean, so they have to accept it. Landlords, I guess, may refuse rent if it's late, a partial payment, or if it's offered in a manner inconsistent um, with the lease, or if there actually had or the eviction has already happened. I mean, what happens, I guess, what happens if what to do if your rent is refused? Review the lease, document, Texas is only a one-party state, so I mean, you can videotape or record yourself trying to make the payment. If it's sent any other way, use that, use that, evidence to, so when an eviction is filed, you have proof that you actually paid, and and continue to offer payment, I guess, every month. I mean, this could be going on for like 3 months, and every month, they'll I guess they'll deny it. They want to stop your rent, but then if you show that you tried all 3 months, that's it's good evidence for you to be successful in trial. And contact an attorney for assistance. The new notice to vacate, I guess, also changed the way, I guess, the notice to vacate is calculated. Um, um, the first full day of a notice to vacate, so it starts off after the notice is delivered, and if it ends in a weekend, a federal holiday or state holiday, um, that deadline is extended until the next business day, so you can't end on a weekend, federal or state holiday. And filing, I guess, an eviction early, and not allowing the full times to lapse is grounds for a judgment for the defendant. So, I mean, I mean, it's easy to make a mistake. So, I mean, I would pay attention to this. Here's a scenario. The notice to vacate was given here. Was on the fourth, and you count the days, and since it's the third days, the first day that could would be on the 10th. For special cases for public housing and subsidized housing programs, including Section 8 vouchers and low income tax credits, have additional termination requirements. Those are spelled out in the HAP contract and I guess the agreement you have with the housing authority. Evictions, I guess, involving public benefits, it also has additional protections. Public housing benefits are still covered by the CARES Act, and public housing, beneficiaries, should only pay their amount into the court registry. So if you lose and you have, I guess, you usually have, 5 days after your appeal to pay a month's rent. A tenant, I guess, it's only has only I guess, only pays their portion of the rent. And so, under CARES Act properties, they're still required to give 30 days to vacate, and that includes VAWA, public housing Section 8 voucher programs, and all the lists here. Um, there's, I guess, for some larger properties, there might be, I guess, databases online, so, but the best practice is to check the property records to see, if any of these apply. Um, so I mean, the CARES Act, I guess, and the new eviction, there's some, I guess, nuances that haven't really been fully established of how courts are looking at it. But but if you think you're a covered property, I would reach out to a lawyer, as soon as possible, um, it what's I guess at least can be overrided. Because it's at the end of the day, a statute overrides the lease. Um, so the actual element of an eviction, deals to who has the right to the possession of property. First of all, I guess the plaintiff has to be, the owner. They have to be harmed by the tenant's breach. The proper notice has to be given, and then the tenant has to refuse to leave. Evictions deal primarily with possession, but landlords can add, so yeah, in theory, I guess evictions only for the possession, but landlords can add the claim of back rent and attorney's fees, but they can't, include late fees or utilities or that has to go through a separate lawsuit. You have a right to request a jury, but you have to file it timely, and depending which court it is, if you're in JP court or the county court. It depends on that time. Um, After I guess the notice vacate, the line expires, a landlord can file an eviction. It has to be filed in the precinct where the property is located. Um, it depends. I guess the trials usually, I guess, the trials have to be set within, I guess, 21 days of filing, and and the defendant has to be served with a citation at least 4 days before trial. The citations must be delivered by constables 5 days after the suit is filed, or the landlord can take another different law enforcement to serve it. Um, I know, I guess there's been a lot of, I guess, discussion in the news about, squatters and evictions, I guess the biggest distinction is that, a tenant has a right, enter the property with a right to possession, and a squatter never had that right. A forcible detainer is a an eviction for a tenant, and a forcible entry and detainer is an eviction for a squatter. Which there's I guess it's pretty I guess it's close I guess the actual procedures, but but if in certain circumstances I guess there's less protections obviously for the squatter. The new law, I guess, now allows a summary disposition to give, I guess it's meant to give, the homeowner or, property owner faster right to the property um than in previous times. Um a court is required to give notice that notice the plaintiff, seeks the property through a summary disposition, which is essentially just a motion saying, that there's no trials needed, and because X, Y, and Z, and 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 I guess at that time, if you have a defense, the I guess if the defendant has to file a counter response, within 4 days to show that there if they actually don't believe they're a squatter, that that there should be an actual trial and it can go through. I mean, the easiest ways to prove, is the written lease, show that you made payments to the landlord, show correspondence, prior demand for possession. Prior evictions. Like something that you can point to say, I'm a tenant, and it can proceed through a motion for summary dispositions. Tenants should, should keep evidence, that to show, always, because it could always happen. If you're facing a motion for summary disposition, call the attorney, call the clerk, ask for, I guess, for an attorney to be assigned. Um, File a statement saying, that you are a tenant and for X, Y, and Z, and and file them as soon as possible with the court, and on the day of trial, bring all the evidence. If you lose the motion for summary disposition, you still have a right to appeal. Um, I mean, trial and JP court is, it's a little bit of a free fall. It's meant, I guess, for that you don't have to be a lawyer to practice in JP court. Um, I mean, I guess the best thing to do is, arrive early and see and talk to the clerk, check in, see what instructions, I guess, judges, I guess, what instructions, I guess, are given. At trial, the judge usually begins with the plaintiff, and then he'll give the tenant a chance to respond. Be prepared to, the judge won't give you legal advice, but I mean, be prepared to, prevent a legal defense. Um, it can only, I guess, it can only be reset once, by motion of the plaintiff, or if both parties agree. And at the end of the trial, the judge will say, one party wins. And always be, courteous, because you, that's being courteous, I guess, will allow you to, just have more opportunities. If you do settle, I guess, some judges, I guess, really push for a settlement agreement, and to be honest, it's helpful for everything. I mean, it for judicial economy. Just be aware, a settlement agreement. I mean, both parties have to agree to it, and the terms have to be spelled out in the agreement. Um, a good, I guess, agreement. I mean, it's very specific, and sometimes the courts provide a standard one. So I mean, you can always negotiate and rewrite it to include what you're going for. It has to be signed by both parties and signed. And just be aware, if and that you're going to have to give up some rights, and it's a negotiating process, and it's a give and take, So I mean, unfortunately, I guess you can't get everything, but I mean, it's a good way to proceed if you're looking to, I mean, if you want to make a settlement, and make sure that you can comply. I mean, there's a lot of times, when I guess I see tenants have aspirational goals, and good intentions, and but I mean, there are at times, I mean, they can't keep up to it, and so I mean, if you do make I guess, an agreement, make sure that you can keep up I guess, that agreement. Um, if you lose, you'll have 5 days to appeal, and you can appeal either by paying a bond or by filing a statement of inability to pay court costs. And you can ask one, um, you can find one online or from the clerks, and and you can sign it, I guess, or talk to clerks and that they'll sign it. Under the new rules, they a tenant has to say that they have a meritorious offense, and it's not just to delay. Within 5 days of filing a statement of inability to pay court costs or bond, if you want to if you want to stay in the property, during the appeal, you'll have, I guess, 5 days to pay 1 month's rent into the court registry, and you have to start paying rent every time rent is due to the court registry. The case will be transferred to county court, and you'll receive, I guess, paperwork of when your new court case is. But the most important thing is to pay the rent, 5 days, I guess, after at the latest 5 days after you file the statement of inability to pay court costs. Oh, there's a new rule that requires all tenants appealing an eviction judgment to pay rent into the court registry. I mean, if there's no agreement to pay rent, then I mean, I guess judges should, I mean, have a discretion to put $250 as a standard fee. The first payment is due 5 days after filing the appeal, and as I said before, after every rental period, whenever rent is due, you have to not, I mean, you don't pay your landlord anymore. You pay the court now. And if you don't pay, I mean, the landlord can seek a writ of possession. And so when the case goes up to county court, it's heard de novo. And the new, I guess, law requires them to be heard within 21 days after the transfer. And de novo is just a new trial, so the previous trial does not count. I mean, at this point, if you didn't have a lawyer, I mean, even more reasons why to have a lawyer is that the formal rules apply. So the rules of procedure and rules of evidence now apply, and I mean, a lawyer is a necessity at that point. Um, I mean, be sure to see, I guess, keep track of, the court as it moves up to the next court, and because at times, they might issue a writ before without you knowing. But so I mean, always I guess keep checking the court records. Um, if you're unsuccessful in county court, you have 10 days to pay a supersedeas bond. But the writ can issue within 5 days. It The cost of I guess unfortunately I guess to appeal to the appeals court after losing county court is very large. It's very difficult, and they I mean I've usually the bond is about 10 times I guess the monthly rate. Um, and some courts, I guess, will allow an immediate writ of possession to be issued if you don't make your rental payments. But I mean, it's at the time, you have very limited options if you lose after county court. Worst case scenario, I guess you lose. What is a writ of possession? It's a writ of possession is just a legal document that just says, the constable can remove the tenant from a particular, unit. um, a plaintiff, can request a writ and ask the constables, and constables have to serve it within 5 days. If the constables usually just post, I guess, the writ on the door, and they say, we'll be back within 24 hours. And if the tenant's still there, I guess within 24 hours, I mean, unfortunately, I guess the tenant just removes, the tenant and all the properties and changes the locks. Um, if it's raining, they won't, I guess, execute on if it's raining, and they'll wait till the first day it's not raining. So, I mean, the timelines, I mean, here's, I guess, like a quick timelines, but of if it's a case appealed or not appealed, um, in short, it's 21 days, I guess, if it's not appealed, and in about 46 days, if it is appealed, that's like the potential days. But so I guess some courts, act faster than the others. Um, so what happens, I guess, is in certain circumstances, if your landlord locks you out. So I mean, a landlord, I mean, can't lock you out, I guess, unless unless you abandoned the property, and at the end of the day, I mean, abandonment, it's really, I guess, a fact specific issue. Um, and but I mean, and I mean, it really depends, I guess, on certain. I mean, it's usually what's in the lease. They can, if they're actually are trying to repair or do constructions or something emergency, I mean, they can lock you out. But I mean, it really is like fact specific. They can't, turn off the electricity without, again, without um, certain, notices being sent out. If you do, I guess, if you are behind and, and this happens to you, you can file a writ of reentry under a lockout, and essentially you just tell the court, like, my landlord, I guess, locked me out and they're not allowing me back in. Under, I guess, lockout, if the landlord is usually has under certain circumstances, the landlord can lock out people, but they have to give you the opportunity to get back in and give you a key within, a reasonable time, within a couple hours or less. Um, and also, I guess, and you file it in the precinct where it happens. I mean, your landlord is required, and they have to give you within 2 hours. They have to give you a key, regardless of I mean, what time of the day it is. And if they fail, I guess, to allow you back in, you can file, I guess, a writ of reentry. Um, the hearing is heard without the landlord, and the judge, I guess, agrees that you were allowed in. They'll tell the constable, they'll order the constables to allow you back in, and if you're and you can recover um up to, I guess, 1 month's rent plus damages and attorney's fees, Uh, but it has to be included, in the lease. What happens if your utilities have been shut off? If utilities have been shut off, you can file a lawsuit I guess in the precinct. It's called a writ of restorations. I mean, your landlord doesn't have to, I guess, appear, and you can just appear, by ex parte. Um, and if the judge again agrees with it, I mean, you can recover damages, for the illegal um utility shut off. So, and security deposits. Your landlord may keep and deduct from the security deposits amounts for damages and charges which a tenant's legally liable under lease for breach of lease. If after I guess the tenant leaves and you send a letter to the landlord telling him where to send your deposit, and at that point the landlord has to send the letters explaining of what they're going to keep, and it has to be itemized. If they don't send an itemized, letter, then it's considered that they're acted unreasonable. I mean, but the first thing is to send a letter with a good forwarding address, and make sure everything's in writing. Um, I guess that's some additional tips, is, if you have a problem, talk to your landlord as soon as it happens, check rental assistance, take advantages of community resources. And if you have issues, with I mean with the I mean never I guess never not pay rent, and and always seek for help, Um um uh, um Lone Star Legal Aid, the Houston Volunteer Lawyers, other organizations, we're here to help. And here are some resources and how to apply. Hey, looking for questions.
Yeah, I will sit here scrolling through. Let me see. There are a couple. Um, One, to answer the question, I will be sending out a copy of the recording and any of the resources that were mentioned earlier. Um, One question that I do get often, and one that somebody had emailed to me prior to, what happens if you've got a landlord that doesn't fix anything, or there are repairs that need to be done, and then the tenant ends up coming out of pocket to make said repairs, or like if there's mold or something that would cause them to actually have to vacate or have to move, what's the tenant to do in those kinds of situations?
I guess the first thing is, before you make the repairs yourself, for the landlord to have a duty to do the repairs, I guess number one is, make sure your rent is current. And then send a letter to the landlord, describing the details of describing the problem and asking them to fix the problem. If you send a letter certified, you only have to send this once. If it's not certified, you have to send it twice. But a landlord at that time now has the duty to do the repairs, and if they don't do the repairs, then at that time you can either you can terminate your lease, you can file a repair and remedy case in the JP court in JP court to force the landlord to do these repairs. But the first thing is first is to send this letter and preferably certified, just so I mean just to activate the duty for your landlords to have to act.
So definitely in writing first, not a
Yeah.
verbal conversation or
Mm,
anything like that. Make
Yes.
sure you follow up in
Yes.
writing. Okay. Someone just commented here. Yes, years ago I rented an apartment garage and gave a security deposit, paid rent on time. However, mold was discovered and asked to move out. However, did not get my security deposit back. Ended up filing in small claims court, and it was granted in her favor. Uh, Landlord did not pay back, so put a lien on the property. How long do you have to wait uh, to expect something? That's a little bit out of the scope
Yeah.
for for this particular presentation, but um
Yeah, I can.
yeah, but
Yeah. I mean, a judgment, I guess, it's active for 10 years, you know. I mean, I guess, pursue there's a specific attorneys that, you know, that are, I guess, collect judgments, and or I'll reach out to them. There's very specific rules, you know. So, I mean, it doesn't have, you don't have to wait till, I mean, um, for them to sell the house, you know. There's other ways around that. Yeah, but I mean, I would talk to one that specializes in collecting judgments.
yeah. But otherwise, if you did put the lien against the house, then you basically are just waiting for them to sell the property or do anything with it before you can collect on it. The lien will stay there. And
Yes.
it's nothing they can do with it. I mean, if they try to do anything with it, then they still owe you the money. But it's been after 10 years. You have to refile
Yeah.
a lien or something after 10 years, right?
Unfortunately, I guess, you know, without, I guess, you have to, show that you tried to execute on it. And I mean, at that point, I mean, it kind of becomes back specific, but I mean, I mean, depending, I guess,
It depends.
yes.
That's the attorney answer. It depends. Unfortunately, it depends, and that does get really specific. So probably can't answer that one in this particular setting. So um, the other thing that I wanted to ask about, I've heard about landlords. When is a landlord allowed to enter into a property and take items, or and what are the non-exempt items that they are not allowed to take or remove for a
Um,
tenant that owes rent?
it has to be, I guess, allow in the lease, it's called landlord lien. It's also very, I guess, fact specific, and you know, I can look more into this, but I don't. It's not something I guess I regularly practice in. But I can, you know, I can look more into this, and you know, and update the PowerPoint.
I've heard people also ask about a landlord coming into your unit, like as a tenant. What's the general rule about a landlord just kind of showing up or popping in, and or when
No,
are they supposed to be allowed to actually come into your unit?
I mean, there. I guess it really depends. I guess again, it depends. I mean, under the lease, you know. But but I would say, you know, something reasonable. If it's unreasonable, I mean, you also have a right to call the cops, you know, if you feel unsafe, you know, if it's unreasonable time, you know. Um, I mean, but I mean, it should be only to for purposes of, you know, the unit and maintaining the unit. I mean, other than that, you know, I would, you know, I would be cautious.
Okay. On average, and I know it kind of depends on the process and kind of where people are at, but on average, after someone receives the notice to vacate on, day 3, day 5, whatever the date that it is, what's the timeline for someone to actually physically be removed from a property from the time they stop paying their rent or don't pay rent to the time they really have to go? Because I know a lot of folks, and I'm saying that because I want to give people like a snapshot or an overview of how long the eviction process actually takes. Because a lot of times people will say, I got a notice on my door, that means I have to leave, I only have 3 days to move out, kind of thing, and they go into panic mode because they don't understand that the notice to vacate is not the actual eviction itself, where they actually have to move. So what does that timeline actually look like?
In JP Court, after an eviction, I guess, has been filed, it's usually around 26 days after filing. If you don't appeal, and if you do appeal, it's around 46 days, you know, to proceed the whole, to extinguish all, I guess, rights is what it's around 46 days.
Okay. So people have roughly almost a month
Yes.
basically after they've stopped paying rent. So it's not
It,
immediate that I gotta
no,
go.
no,
Okay.
and if not, I mean, then at the time, if they're, I guess, sometimes they get evicted without a court order, and that's wrongful, and that's wrongful eviction, and that's a different claim.
Okay.
Yeah.
What's the immediate remedy if a tenant is locked out of their unit without going through the
Um,
this kind of a process?
is to file, I guess, a writ of reentry with the their JP court and their precincts, and just let them know, I'm a tenant, I mean, I have asked for a key, and they haven't given me a key, and I should be allowed back in, and they will be allowed back in.
Will they need to get a lawyer to do that, or is it something that they can do kind of on their own?
This I guess is more, I guess, I've seen, I guess, tenants, do this on their own, I mean, and be very successful, and it's very, I guess, it's more simple, I guess, simple than other, I guess, law things, but I mean, I still would recommend, to apply, I guess, to Lone Star, and I mean, if we can help.
So don't automatically
Yeah.
assume. Don't wait until the last minute.
Yeah.
Contact and reach out to somebody for help. I did ask Benjamin, your other colleague at Lone Star Legal Aid, about other resources and things that are available, and he mentioned the Houston Advocacy. Uh, what's it called?
Houston Eviction Advocates.
Yeah,
Yeah,
Houston Eviction Advocates. How does somebody get in contact with them?
I don't, I guess, I will, I guess, update the presentation to include them at the end. But there, I guess, they do JP Court representations and precinct, I guess, 1, 5, and I can't remember which one. Um, I can't remember. I guess they do in-person representations there, and they'll, I guess, if you apply there, you can represent, they'll represent you on the spot. But I mean, I'll have to look and get their contact information. I don't have that on top of my head.
That'll
Yeah,
be one of the resources that'll be
yeah,
included on
yeah,
the slide. I mean, on the email,
yeah.
and that's the link. I put it in the chat. The link for the website for those that may be interested or need assistance. And then let me. Someone just asked about Lone Star Legal Aid as well. I want to make sure that your link is in the website. The chat is included when I send out the recording, so you guys will have access
Yeah.
to the links. I like putting them in there so that they'll have them there as well. Okay, so to apply for the Lone Star Legal Aid, their link is included, as well as the Houston Eviction Advocacy Center. Their uh, their link is there as well for more information about that. And let me see if there were any other questions that were emailed or that were. We already talked about the mold, invasion of privacy. Uh, help with an appeal. If someone's at least anyone over the age of 18 that's a tenant, are they supposed to uh, receive eviction paperwork or eviction notice as well? Is it
Um,
anyone over the age of 18 or
I think it's over 16. I think.
16?
Yeah.
Okay. Blah, 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 blah. And then what is the process if you've got a landlord that just absolutely won't make any kind of repairs, even if you reached out,
Yeah.
sent emails and what have you?
At the time, you can send them a letter saying that you're going to terminate your lease, and I mean, and you won't be responsible for any, termination fees. You can file a lawsuit asking a JP to force them to do the repairs. Um, and 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 you can also, I guess, go through the other remedies, which I mean, I guess there's more, I guess, nuanced ones, but those are the two main ones, is to file a repair and remedies case in JP court and to terminate your lease without penalty.
What does someone do if they find themselves in a domestic situation, and then they have to leave or they have to vacate, or
Um,
can a landlord still file or sue them for, back rent or
there's certain, I guess, I don't have, I guess, the procedures in front of me, but there's certain things if the tenant gives the landlord information about it, and from, it's usually, I guess, a report from a advocate,
Mhm.
and to explain the situation, I mean, they can be excused, and let off the lease. But it's very, I guess, fact specific, and I don't, I guess, it's not something I guess I regularly practice in, so I'll have to look into it.
Okay. And when does a tenant go from being a tenant to a squatter? Like as soon as they stop paying rent, or when are they considered a squatter?
A squatter, I guess it's not a tenant. I guess it's someone that came in without legal, I guess, right to begin with. I guess a tenant doesn't pay. They might, become a tenant sufferance or different types of tenant. But I mean, they're not. I guess they're not a squatter.
Okay. I'm paraphrasing a lot of the questions here because some of the questions that got sent are real specific and they go into a lot of detail. So I'm trying to form it in a way that it's not, you're not bordering on legal advice. So, uh, okay, I think that was just about it. And I don't see any questions on our social media page. So again, the phone number and the contact information for you guys, if somebody was interested in applying for Lone Star Legal Aid, what's the website?
LoneStarLegal.org and 1-800 I can't sorry it's 733-8394 it should be I guess somewhere up here.
Okay. All right. Are there any other questions from any other participants that are joining us today? Let's see. For later on this month, sorry, we do the eviction presentations every other month, the third Tuesday of every other month. We used to do them every month, but now we're going to every other month timeline. So if you do have any other questions or please feel free to reach out to Lone Star Legal Aid or send your questions to me, and I'll make sure that it gets directed. If you guys find yourself in some kind of a financial issue or situation, that's going to impact you and potentially put you in an eviction situation, please reach out immediately. Don't wait until it's the day before you're supposed to show up for court before you actually reach out for help because unfortunately they're limited as staff. So the availability of having somebody to help you like immediately is probably going to be slim to none. And you don't want to find yourself in that kind of a situation. Also, communicating with your landlord makes a huge difference. You'll be very surprised as to how many, you know, if you make the arrangements prior to, if you it's coming up on 5 days before the first of the month or what have you, and you're not sure if you're going to be able to make your payment on time, communicate with the landlord, say, hey, I'm coming up short, I lost my job, I had this unexpected yada yada yada, is there a payment arrangement or agreement or something like that that can be worked out? Communicate with them and ask them, what's the worst that they can tell you is no. But if you don't ask, you won't know if there's another option that is available to you. So please make sure that you do actually communicate, reach out for some kind of assistance or some kind of help prior to your eviction uh, actually taking place. Let's see. This was the other question that I had. If someone does get that notice to vacate, they end up leaving. Can a landlord still file an eviction against them and get a judgment against them, even though they've already, since the eviction is a lawsuit to get the possession of the property back? If they've already gotten possession, can they file that and then, have people's credit and all this other stuff impacted by a judgment being against them?
I mean, they're not, I guess they shouldn't do that, and I mean, and I mean, because I mean, like you said, it's primarily a a trial to get possession. If they already got possession, I mean, they can I mean, file a separate um lawsuit. But unfortunately, I guess it happens too often because I mean, you've already left, you don't receive the notices, and the landlord still proceeds, and you don't find out till later. Um, just I guess if you think I guess if you leave before the leave before notice expires and they still file, that's a defense, and still contact Lone Star Legal Aid. You have a great defense, and that's well because it happens too often.
What kind of documentation or preparation or something that they need um, to basically cover themselves? Like if,
Yeah.
if I'm a tenant and I moved out, what do I need to do to make sure that
Uh,
I've got something that shows I moved out before you filed? the lawsuit.
Make sure, I guess, the landlord, I guess, gets your keys, under the lease, I guess, lets you know, where you should, I guess, return your keys, to, I guess that kind of signifies, um, I mean, that you left, I guess a lot of times, landlords, oh, like, I've heard, I guess, landlords say, oh, they were still there, they had stuff there, I mean, make sure it's fully cleaned out, and you attempt to return the keys somehow, and you record that to them.
So take all your stuff with you because as long as you're
Yeah.
gone, but your stuff is still there,
Um,
technically
they can make the argument, I
they
guess.
should make an argument. Yeah, I thought so. Okay. I do believe that is all that I have. And I don't have any other questions here. So we want to thank you again, Newton, for filling in for the normal
Yeah.
folks that would typically come out. So you did a great job. So thank
Yeah.
you. Appreciate that. Again, a copy of this recording along with the links and resources for the various advocacy centers, um, legal aid organizations that are out there. All of that will be emailed out to everyone so that you can go back and review. If you know of neighbors or somebody that may find themselves facing eviction, please share this information with them as well. Um, because it doesn't do us really much good to keep this kind of information to ourselves. And like you had mentioned, I call the folks, out there on social media, the street committee. The street committee is going to tell everybody what they heard or what they thought or what they found on if it's not applicable, because some of those things are not applicable to Texas laws and how things operate here in Texas. So you can't yeah, just be careful about where you receive your resources and your information and make sure that it's something that's pertaining to where it is that you actually live. So, and then regardless of where people are joining us from uh, here, because we get folks that are all over the state, that the information that he did provide is for the entire state of Texas, Texas law, Texas eviction process and procedures. So know that the information is valid for the state of Texas, not just for Houston or for Harris County or anything like that. So be mindful when you're doing your research out there that you are looking at Texas uh, eviction laws, Texas property codes, and things of that nature. So, but again, if there are any other resource or anything that you guys are currently facing that you may need more information about, please fill out the survey when it pops up onto the screen so that we'll know what it is that we need to provide for you all. So, and again, if you have any other questions, please reach out to us and let us know, and we'll be happy to try to assist as best as we possibly can. So, again, we want to thank you on behalf of the A Month of Service Collaboration and all of our partners. And thank you, Lone Star Legal Aid, for providing this information for us this afternoon. So, without further ado, we're going to give you guys your time back. So, hope you can join us again for other presentations that we have that are coming up. Our schedule is going to be attached in the email that we get sent out to you as well. So, you all have a wonderful remainder of your day. You all take care of yourselves, you stay safe, and hopefully we will see y'all soon. Thank you very much. All right.